This is Frekhtman, a New York City personal injury trial attorney. And today I wanted to talk about a question that's very, very interesting. And actually, I hear some people ask it, and also I see it a lot in all this marketing. And that is it helpful to have a personal injury lawyer on your case who is aggressive? And by aggressive, I mean somebody who's tough, like you see a lot in marketing, right? I'm the pit bull lawyer, or I am the hammer, and you actually with a hammer or a baseball bat on top of a truck, like I'm gonna hammer the insurance companies. I'm gonna get them to pay. But how? Just by being aggressive? By yelling at them? By, you're not gonna take the hammer to the insurance companies, right? That'll land the lawyer in jail. So how is being aggressive going to be helpful? Well, and is it helpful, right? Is being an aggressive lawyer a help, or is it a hindrance? And I think that's an interesting question. I think fundamentally, if you're just being aggressive for the sake of being aggressive, it's not helpful. But if you're being aggressive, like a tactic in terms of moving the case forward, then it can be very, very helpful. What does it mean to be aggressive in terms of handling the case? You got to roll up your sleeves and work hard, and you can't sleep on a case. You don't have to be aggressive, like you don't have to scream at the adjuster and say, "Oh, I'm a hotshot lawyer, you better pay me the full policy, $100,000, or else I'm gonna, get you a trial." I don't think that's really gonna work. In fact, you should be professional, because if you're professional with the adjusters, with the insurance companies, with defense lawyers, then they see you as credible, they see you as professional. And your history of trials and your history of verdicts and results speaks for itself. So you don't have to huff and puff and say, "I'm gonna blow your house down." That stuff doesn't work. But what you do have to do is litigate the case like Atticus. You have to litigate the case aggressively. You have to love the client. You have to be in it. You have to really be in it. You have to live the case, and you have to push the case. And you can't sleep on the case. That's important, because cases can be easily delayed if the lawyer is not prosecuting the case efficiently. The other thing you have to do is you have to be thorough. So when I say be aggressive, I don't mean don't be thorough, just go ahead and plow through it like a bull in a china shop and put it on the trial calendar. But then when push comes to shove and you're before a jury, you don't have the proof, you don't have the evidence. So you have to be thorough. You have to speak to witnesses. You have to get that human story. You have to do a liability analysis, maybe hire an expert. You have to do damages workup, make sure the doctors that are treating your client can come to court and they're going to testify and they're going to give you what legally you need in order to win the case. Like, are they going to give you causation? That's a big one, right? If they don't give you causation, then why even come to court? So that's very important. So you have to move your case, and moving your case can be aggressive, even if you're the nicest, sweetest guy, right? You don't have to even raise your voice. But if you're moving your case, the adjusters see that as aggressive. And they actually time all of that. Like, for example, you file a lawsuit, and then the insurance company hires a defense lawyer. Now they've answered or appeared in the case. So then how long from that appearance are you going to take to file your bill of particulars, answering their questions about, like, what did we do wrong? What are your injuries? Are you going to take like 30 days? That's good. Or are you going to take 6 months? And then now they write an email, "Hey, I think so-and-so is sleeping on their case. It's been 6 months. They're not doing even a BP, a bill of particulars." And then are you going to get that preliminary conference quickly with the judge so that you could do depositions? Or are you going to adjourn depositions and then just let the case linger? So that's being aggressive in my book. And the other thing that's really important with respect to this is your position on settlements, because some lawyers are going to call the insurance company and they're going to make a demand. And the insurance company looks at your demand and they think, well, this is the highest number we would ever possibly, in the world of worlds, have to ever pay, right? So if it's $1 million policy, for example, and your lawyer calls and says, "Well, I'm demanding $850," well, you just saved the insurance company $150,000. You just gave them a gift for $150,000, because you're never getting that $1 million unless you take it to a jury verdict, because your demand is $850, right? So you have to really analyze the case. If the case is worth it, what I like to do is just demand the policy. Say, "Look, I will accept." I don't even like the word demand, to be honest. I really don't like it. I hate the word demand. Don't use the word demand, because demand makes you sound like you're begging, right? "I'm demanding, please give me, $1 million." And that's how they treat it too. That's how the insurance companies treat it, right? They're like, oh, your demand is $850. That's so high. Oh, we don't have it evaluated like that. We have it evaluated as a $45,000 case. Or, oftentimes what the insurance companies will do is they'll take your demand, what you ask for, the number, and they'll give you a third of that, and they'll think that's what you really are looking for. So a lot of lawyers will think, hey, if I want to settle the case for 100, I'll demand 300 because I know the insurance, but it's all a game. It's all nonsense. What I like to do is look, if you have the injuries, if it really is a life-changing forever injury, like a traumatic brain injury, a spinal fusion, any kind of serious injury, a burn injury, what I like to do is just say, look, just tell me what the policy is. Give me the primary, give me any excess umbrella, and then that is what I will accept. And I'm giving you the settlement opportunity. So I flip the script on them. I say, look, I'm being reasonable. In good faith, this is your settlement opportunity. You have $1 million policy. Your policy holder, your insured is Mr. John Smith, the driver. He doesn't have any other coverage. I see the affidavit of no excess. There's no umbrella, no concurrent, no supplemental. That's all you've got, right? The $1 million. So we'll take the $1 million because we have a trimalleolar fracture. We have open reduction, internal fixation, plates and screws and rods. We have serious, serious injuries. We'll take the $1 million. You have 30 days. Pay it. If you pay it, we're done. If you don't pay it, fine. We're preparing the case for trial. We're going to trial. But guess what? It's not going to stay at $1 million. No, because I have to do all this work. So now when I go to trial, it'll be $5 million. And at that point, if you don't have any insurance, then you have to advise your policyholder. He has to get independent private counsel because who's going to represent him for the difference if the jury allows for $3 million or $4 million or $6 million? Who's going to pay the difference if you don't have any insurance? Or maybe because you're not evaluating the case fairly now, right? You're not following your duty of good faith and fair dealing. You are acting in bad faith. Maybe because of that, the judge will order you in bad faith, and then the insurance company will have to pay the difference, So that's how being aggressive in my book. I like to do that on the big cases. So I hope this has been helpful. So when thinking about being aggressive, remember, it's not about just saying, hey, I'm a bulldog, I'm going to bite you, or yelling at people. It's about being professional, but being efficient, moving the case, being thorough, and then with settlement, sticking to your guns, not backing off and being fearless. Just saying, look, this is what the case is worth. If it's worth $1 million, pay me the $1 million, 30 days, you don't pay it, fine. We take it to trial, that's it. And then do it, take it to trial, get that jury verdict. Look, sometimes you will say it's worth $1 million. They'll call your bluff and say, look, no, I'm not gonna settle it. And you have to take it to trial. And then you'll hit them for $1 million. Maybe you'll hit them for $2 million. But sometimes you'll do the same thing. You'll take it to trial and you'll hit them for 500. And sometimes you'll take it to trial and you'll get 0. There are so many defense verdicts. They happen. And that's just part of life, because this is not an exact science. But you have to just stand in the fire, run into the fire, and do it. That's all it is. Okay, I hope this has been helpful. And we are here for you. Let us know what questions you have about hiring an aggressive lawyer or any questions about personal injury at all. Okay, have a great day, everyone. Bye-bye.